Hi, I'm Jackie Cannon. I'm one of the shareholders here at Robb and Cannon. As we celebrate Pride Month this June, I wanted to take the time to give you a brief history of how the Supreme Court of the United States has addressed the issue of same-sex marriage. The first time the Supreme Court had the ability to address the issue of a same-sex marriage was in the case of Baker versus Nelson in 1972. The parties were Richard Baker and James McConnell. Now, the parties had actually obtained a marriage license in 1971, as Mr. Baker had changed his name from Richard Baker to Pat Lynn Baker. In that case, the Supreme Court dismissed the case without ruling on the merits or the legitimacy of the parties' same-sex marriage. The next time the Supreme Court had the ability or the desire to address the issue of a same-sex marriage was in 2013 in the case of U.S. versus Windsor. That case was specifically related to the Defense of Marriage Act that was with the federal government. So at that time, they limited the scope of their ruling to addressing only the federal government regulations as dealing with same-sex marriages. In DOMA, the Defense of Marriage Act, marriage was defined as between being with one man and one woman, and the court found that to be unconstitutional. Based on that ruling, it laid the framework for the case that dealt with states recognizing same-sex marriages in Obergefell versus Hodges in 2015. In Obergefell, the Supreme Court found that same-sex marriages should be recognized as though or with the same legitimacy as heterosexual marriages. With that landmark case, it opened up a wide range of issues for family law, as well as probate and guardianship, and additionally criminal law, as same-sex marriages now being recognized gave many of the benefits, not just financially, but in courts of law, as they would had the parties been heterosexual. We still don't know the full scope of how Obergefell has changed family law, as it seems every single year we're finding more and more ways that that case has fundamentally changed the way that courts are looking at not only same-sex marriages, but families, especially with regard to children. Prior to Obergefell, and the cases that have come out since then, most of the time, in order for a non-biological parent to be recognized for a child born during a marriage or in a relationship, they had to adopt that child or have a gestational agreement. The cases that are coming out now are attempting to award parental rights to those non-biological parents without having to take the steps of adoption or gestational agreements that a heterosexual couple would not have to take. We here at Robb and Cannon are able to help you with your same-sex marriage issues, as well as any child-related issues in your same-sex relationship. I appreciate you taking the time to watch this video blog, and happy Pride Month.